The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Tampa. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. And this is the last Tuesday of the month, and that means K. Bender Rimbaum and attorney Kirsten Hens. Let me welcome. Hey, this is our 16th year. I'm so proud of that. Let's welcome attorney Kirsten Hens. Good afternoon, Kirsten.
Good afternoon, Steve.
Can you hear me okay?
I can.
Good. Well, we've been having all kind of problems today, and anyway, we got them fixed. And I got to tell you this, Kirsten. We got a call from I forgot. They're not councilmen. They represent the city, and they work on the rules for HOA and condos. And I got a call from, I forgot, maybe assemblyman or something. I forgot anyway, he had heard about your show and wanted to come on. I think he wanted to come on with Robert next week, but Robert's going to be out of the country. But that was kind of cool that the show has built that kind of name up.
Yeah, that is cool. That's wonderful to hear.
Yeah, he was bragging. This is funny. He was bragging. He's one of the few who actually live in a condo association. And he was kind of making fun of all the others because here they are making laws, something they're not even involved in their personal life. So anyway, I thought that was kind of cool. Hey, welcome. I'm glad you're here. We're on the air. Everything's great. Tell people about K. Bender Rimbaum.
Yeah, thanks, Steve, for having me yet again.
We love having you on.
Thanks, Steve. For those of you who are first time joining the show and are not familiar with K. Bender Rimbaum, we are an exclusive community association law firm. So that means that we represent community associations, your condominium, your HOA, and your cooperative associations. We are a Florida-based law firm. Our main office is down in South Florida in Pompano Beach, but we do have other locations, including Palm Beach Gardens, the Orlando area, and then I manage the West Coast office for the firm, which is located in Tampa. But, we pretty much represent community associations throughout the state of Florida, and if there's a region, if you will, for the West Coast, then I would be pretty much representing associations up and down the coast: Sarasota, Venice, Newport Richey, and so forth.
Kind of behind the scenes look at the show. This show right here is one of all of our shows we do throughout the country. This is one of our most popular shows, and we're so glad that we can bring this show to you. Kirsten, let's get started with questions. Are you ready?
Do it. I'm ready. You had a lot.
Can you believe? I mean, were you surprised? God, we must have gotten 4 pages of text and most of them came in the last 4 days. But let's get started. Let's go to Deborah in St. Pete. She says, our manager says it's illegal to have an in-person interview for potential owners and renters. Is that true?
Well, it's not so much that it's illegal. I guess the big question is whether or not this particular association is authorized under their governing documents to screen applicants. So that means require applicants to submit an application where they fill out certain information about who they are, including some character references, as well as run a background check on the applicant, and that could include criminal as well as financial credit check. And so if your governing documents authorize the board to run these background checks and screen applicants, then an interview would typically be part of that application process. And the reason I say, I'm referring to the governing documents is because, 720. This listener is in a HOA. I presume I'm governed under 720. So 720 doesn't really address sale or lease approval rights, nor does the Condominium Act or Chapter 719. So this is something that is going to be strictly a document-specific issue, right? And so you have to have specific authority in your declaration to approve, disapprove applicants. Now, with regard to interviews, typically an interview is I wouldn't call it an interview. I would refer to it more as a meet and greet opportunity. And I would, my recommendation is not to have that meet and greet meeting until after the board has reviewed all the application and background check and then has decided to approve the applicant. And the reason we recommend to do it, at the tail end of the application process is because if the board ends up meeting the applicant and then later on decides to disapprove the applicant, then that might give the applicant potential basis to claim discrimination, right? And so you want to try to minimize those discrimination claims by simply reviewing the application, the background check, making a determination, and then only meeting the applicant face-to-face if the board has decided to approve.
This next question, Kirsten, seems like we get a lot of these especially condos, having a hard time getting people to run for the board. This is from Greg in Clearwater. He's a condo. He said, if no one runs for the board, do you still have to do elections? We are 121 units, and we're lucky to get 20 people to even show up.
Yeah, no, I feel like I'm seeing a lot of this where we have boards that basically can't seem to even fill vacancies. Forget, running for the board.
Right.
There are directors who are resigning, and the seated board members can't even fill the vacant seats, and many are having issues with even meeting quorum. So, quorum is the minimum number of directors that need to be present in order for the board to conduct a meeting, right? And conduct association business. So if you can't meet quorum, you technically can't, conduct business. You can't operate. And that's a challenge for, many associations, whether it's condominium or HOAs. But to answer the caller's question, I mean, essentially, if nobody wants to run for the board, or if you don't get, 20% of the owners, if 20% of the owners haven't submitted an election ballot because there's just apathy or, for whatever reason, then no, you can't have an election. And so the seated board members simply roll over. and they
Okay.
could serve, for another term unless any of the directors resign.
Okay. So they don't, if they can't get enough, they don't even have to do an election.
Right. Well, I mean, how would you do an
Well,
election?
yeah. Imagine this. Here's another Clearwater. Pete in Clearwater. One. This is an HOA. Kirsten wants to know: can we do voting certification like condos?
So voting certificates, yeah, I mean, voting certificates, it's basically a document whereby if a unit is owned by either multiple individuals or is owned by an entity such as a limited liability company, then the voting certificate would designate who among the multiple owners or which representative of the entity would be the voting member of the unit, right? So that's essentially what a voting certificate is. It just designates who is actually going to vote for the particular unit. In order to have the ability to require these voting certificates, essentially you have to have the authority to do so in your documents. Specifically, the bylaws would be the governing document that would provide that authority. So I would encourage the caller to take a look at the existing bylaws, see if there is a current requirement for voting certificate. If there is, then see when does it apply. And if there isn't a requirement for voting certificate in the instance of multiple individuals owning a unit or entity owning the unit, then this could be an area of amendment. So you would need to propose an amendment to the bylaws to require voting certificates. If there is a requirement for voting certificates, then essentially that means that on any issue before the membership that the membership gets to vote on, if if an owner doesn't submit a voting certificate in advance, the board could potentially disqualify the vote. Right. And so that's essentially, the benefit of having voting certificates. If you don't have voting certificates, then obviously you can't disqualify certain votes.
Right.
So
Jerry in Tampa, this is another HOA. We get a lot of these too. God, there must be a lot of people who are delinquent. He said, if I'm delinquent, can I still run for the board?
So with HOAs, the answer is no. If the candidate is delinquent, they have to be able to bring their delinquency current up to basically by the last date by which the candidate can nominate themselves for the board. The tricky part for HOAs is, well, when is that last a date by which the candidate can nominate themselves? With condominiums, that's typically the date by which an owner needs to submit their notice of intent to run, right? And the statute provides a specific time frame. With HOAs, it's not as clear cut. The HOA statute does allow owners to nominate themselves from the floor on the date of the annual election meeting. So presumably that would be the last date by which the candidate has to bring their account current. However, the statute also provides that if the bylaws identify a procedure for candidates to nominate themselves in advance of that annual election meeting, then they can dispense with nominations from the floor on the date of the annual meeting. Okay, so I would encourage the caller to take a look at the bylaws, see, is there a process by which a candidate can nominate themselves in advance? And if so, confirm with the board, with management, and then that would be the last date by which the candidate has to bring their account current.
Here's Craig in Tampa. I don't understand this. Good luck on this one. It seems if a proxy ballot for election, not a proxy for a quorum, it seems that this means that the owner's vote is not secret. Makes no sense. Your thoughts?
It makes no sense to me either.
Yeah.
You know, with condo elections, the election ballot has to be secret, right? Condos have the whole, inner and outer envelopes and whatnot. So no question, in condos, election ballots have to be secret. With HOAs, well, again, it's not as clear as with condos. The HOA statute essentially allows associations to determine how they want to carry out their elections. And so, different associations could have different election process. The big takeaway is that your election process has to be specifically set forth in your bylaws for an HOA. And so if your bylaws do not necessarily require secret ballots for elections and allow owners to vote in elections by proxy, well, then that is the election procedure that you have to follow. So it's not uncommon in HOAs for elections to be done by proxies. It really all depends on what your bylaws provide. And if the board doesn't want to allow election voting by proxy at elections, well, then you might have to amend your bylaws.
Hey, we're going to go to a break. Kirsten, give out the phone number and the website that people can reach K. Bender Rimbaum.
Yeah, the website is kbrlegal.com, and there's lots of great resources on the website. We have the legal morsel that we publish with updates in the law. Then there's the Rimbaum roundup that we do as well, which is a newsletter that gets e-blasted to any board member, owner, any individual really that subscribes. And then we also do, as you know, a lot of, webinars and seminars for both managers and board members. So there's a whole calendar full of wonderful, webinars and seminars that callers can take a look and sign up.
We're going to go over when we come back. When we come back from break, we're going to go over all those. You got a busy month. We're going to go to break. What's that phone number again? Kirsten?
Yes, 954-928-0680. And that's our main number.
Perfect. We're going to go to a short break. When we come back, we have more with K. Bender Rimbaum. Kirsten Hens.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. It's almost the K. Bender Rimbaum hour. We've got Kirsten Hens, attorney there at K. Bender Rimbaum. And God, you got some, we're almost at the end of the month, Kirsten. I can't believe I'm saying, I'm looking at, wow, you got a busy schedule, but we're already going into September already.
I know. I can't believe it. And before you know it, it's going to be Thanksgiving.
I know, I know. It's crazy. So you've got a schedule there. Let's tell people what you've got your classes coming
Yeah,
up.
let's see what's happening. So for the days that remain in this month, we have on August 27th, that's tomorrow, we have a covenant enforcement class. So that's a class that talks about basically what your enforcement remedies are, from fining to suspension of use rights to, litigation. So that's tomorrow via Zoom at 11 o'clock. Also, August 27th, tomorrow at 5 p.m. in the Tamarack area. So that's down in South Florida. There's going to be Ask the Attorneys. It's an open forum, and that's going to be conducted by attorney Andrew Black. Then August 28th, on Thursday at 11 a.m., there's going to be a webinar via Zoom. What every board member should know, and that's going to be conducted by one of the named partners, Jeff Rembaum. Then Friday, August 29th, starting at 10 o'clock, Alan Schwartzide, who is the managing attorney for the Orlando area, and myself, we will be conducting the condominium board certification class. This is the 4-hour class that's required by the state. Then moving on to September 11th at 11 a.m., Lisa McGill will be teaching the new Condo board member annual legal CEU class. So for those who are aware, the condominium statute requires not only the 4-hour board certification class, but then an annual continuing education credit. And so this particular class that will be taught on September 11th has been approved by the division to satisfy that condo board member continuing education requirement. So that's September 11th. September 24th, I will be teaching a class on elections for community associations, and I will be teaching that with Get Quorum. So for those of you who are not familiar, Get Quorum is an e-voting platform. And so we'll be talking about elections and some of the new statutory changes that just went into effect July 1st regarding elections, as well as e-voting. So you don't want to miss that. Then September 25th, we're also going to teach, again, that condo board member class that satisfies the continuing education requirement. That's at 3 o'clock via Zoom. And then on October 15th, I'm actually going to do an in-person seminar for a change at the Grove Restaurant in the Lakewood Ranch, Sarasota area. That's, again, October 15th. Registration will be at 8 a.m. We will be serving a delicious complimentary breakfast. And I will be talking about guest restrictions, as well as the process of approving and disapproving purchasers, as well as tenants. There is limited space. I believe we can seat up to 40. So if you're interested, be sure to register sooner rather than later. That's all we got.
Amazing. You do all these free classes. You do, you have your attorney work to do, and
And if
you do a lot
possible,
of the classes.
yes, and if possible, we try to treat with a delicious breakfast or lunch
Yes.
and learn, or breakfast and learn.
I think that's one of the things that's so amazing about K. Bender Rimbaum. You're really about education. You do shows like this every month. You've got classes throughout the month, and you're always out there educating. And I think that's amazing because I got to tell you, Kirsten, there's law firms out there that stick up a sign that say community association law, and then they got bankruptcy, criminal law, personal injury law. This is the area that K. Bender Rimbaum concentrates on.
Correct. This is our one and only, our sole, our practice area. It's funny you mentioned that. I was just talking to a board member of another association who is looking to switch because they just received a legal opinion from their counsel that it's completely contrary to law, and I just can't believe that. The only way that they would have given that opinion is because they don't really concentrate in this area of the law. So, for those of you who are looking for association counsel, really strongly encourage you that you seek out a firm that really specializes in this area of the law. It's become too complicated.
Yes. And you know what? I've gotten phone calls here that associations were unhappy with their law firm because they would call with a question. And listen, you've got a full plate, but to take a week and a half to get back with you, and there's several communities that actually left their firm and went with K Bender because customer service to you. I noticed that the first time I went to your main office, there was three I guess secretaries working there that greeted people. I mean, that shows how important customer service is to your firm.
It is, and I feel like attorneys seem to forget that at the end of the day, we're still in the customer service industry, right? And so you kind of have to provide timely responses and pick up your phone.
Right.
Another complaint I hear all the time.
Yes. So
the attorney's going to call me back.
Let's get back. I've got so many questions here. Kenny in Tampa, this is a condo now. Thank you for, please, if you can, when we love your questions, but let us know if you're a condo or an HOA. It does make a difference. Kenny is a condo owner, wants to know if owners can ask questions at a general board meeting.
Well, I'm not sure what a general board meeting is, right? Because typically, there has to be an agenda associated with the board meeting, or at least a meeting at which the board is conducting association business and voting, right? Passing resolutions. So if that's the board meeting we're talking about, then typically owners are entitled to not only speak and ask questions about designated agenda items, but last year or 2 years ago, the statute was 718 was amended to also allow owners to ask questions regarding reports on the status of construction or repair contracts, right? So if you're a condominium association that's undergoing milestone repairs or anything related to your SERS, then owners can ask the status of these construction projects. Can also inquire about the status of revenue and expenditures during the fiscal year. And then can also ask really any questions on any other issue affecting the condominium. So,
okay, Kelly and Brandon, this is another condo. We have no Kaufman language, and we voted down the reserve. Do we still have to do the SIR study?
So, not sure what that means that they voted down the reserves. But I think at this point, the position of attorneys who practice in this area of the law, I think the overwhelming opinion is that it doesn't matter whether or not you have Kaufman language in your governing documents. The SIRS and milestone requirements would apply to your condominium, provided they fall with your condominium building falls within the 3 habitable stories or higher, right? So that was a change in the statute that took effect July 1st of this year. So the statute now clarifies that if your condominium has 3 or more habitable stories, then you are required to do the SERS. And the deadline was extended to December 31st of this year, of 2025. So there is still a limited time remaining to comply.
Brooke, and this is St. Pete. This is an HOA. Here's another one of those having a hard time getting board members. We only have 2 board members, and we can't get a 3rd board member. How do we get anything done in our property? We have tried so hard to get a 3rd board member. We can't even have our trees trimmed or pressure wash.
Yeah, that is a problem. And that's assuming that the size of the board for this HOA, in fact, is requires at least 3 directors, right? So, yeah, I mean, really try to knock on doors. I mean, you really need to get the message across that if you don't get another director, or at least enough directors on the board to constitute a quorum, then yeah, the association can conduct business, right? Yeah, you won't be able to approve contracts. Vendors might not be able to get paid. Projects might not get completed, and so that's a problem. There is also the risk of a receivership situation. Right. So if there's not enough individuals, owners that are willing to get on the board, you're potentially looking at a receivership situation where really any owner can petition the court to appoint a receiver. And the receiver will essentially, conduct association affairs until the board is able to fill those, enough seats to constitute a quorum. And those receivers are not cheap. I mean, their hourly rate can range anywhere from, $200 an hour, plus. So.
Hey, Kirsten, it's amazing. You hear about owners and they have complaints all the time, but they don't run for the board. I mean, if you want to get change made, that's a good place to start, I would think.
Oh yes. that is the $1 million question, right?
Yes.
Those owners who complain or who are constantly challenging the board and yet don't get on the board. So
it's amazing.
It was only that easy.
Let's go to Jason in Tampa. He said, this is Condo. Our board for Condo Association is passing a new amendment on renting that says no more renting unless you own the property for 2 years. They want $150 for each person's background check. Can they actually do that?
So this is for condominium?
Yes.
Yeah, so I mean, the board can propose an amendment to the declaration to institute, I guess this is a lease moratorium. So you can't lease for the first 2 years after you've acquired title to a unit. And, presuming the amendment passes, right, it would be a covenant. The thing about leasing amendments with condominiums is that there is a provision in the statute that essentially says that an amendment to a declaration that prohibits leasing or restricts the term of the lease or how often you can lease, these types of amendments would only be effective against owners who vote in favor of the amendment and then owners who take title after the effective date of the amendment, right? So there's a limitation on to whom this amendment would apply. The more complicated question, of course, is whether this provision in the statute would apply to your particular association, to your particular community. And that will require an analysis of whether or not your governing documents have what is known as Kaufman language. So Kaufman language is basically contain the magic words as amended from time to time after reference to Chapter 718. And typically you'll find that in the first couple of pages of your declaration of condominium. There might be a statement to the effect of that, this condominium or this association is governed under Chapter 718. And then it might say as amended from time to time. So if you have that language, that's what is known as Kaufman. And what that means essentially is that if you have Kaufman language, it means that changes to the statute that affect substantive vested rights of owners would apply to your condominium retroactively. If you do not have Kaufman language, then the law that would apply to you was the law that was in effect when the declaration was recorded. And changes that affect substantive rights, well, a good example of that is this lease provision in the statute, right? That tells you to whom this amendment would apply. And so if you have Kaufman language, then essentially you are subject to this change in the statute. And then you have to be basically, in terms of enforcing that amendment, just be aware, who voted in favor of the amendment. And then, you'll have to keep track of who took title after the effective date of the amendment. If you don't have Kaufman language, then, you could make a constitutional argument that this section in the statute does not apply to your community, right? Which means that you're not subject to this particular section in the statute. And so if you do propose a lease moratorium amendment and it does pass, right, if enough owners approve it, then the association would be able to apply it to all the owners. Okay, but again, this typically is an involved analysis, and so I would encourage you to to get with association legal counsel to confirm this. I think there was another part about an application fee. Is there another question?
$150 for each person for the background check.
Yeah, so the statute does say that as long as the governing document authorize the association to charge an application fee, and that's presuming the association even has the ability to approve or disapprove leases, then yeah, the association can charge an application fee. The current maximum amount the association can charge by statute is $150 per adult occupant, and that fee is adjusted by the division every so often. Don't recall off the top of my head how often, but the division will adjust it based on, I believe, the consumer price index.
Okay. Greg and Wesley, this is a condo. He said, our docs say that if the pipe serves only my unit, then I am responsible to repair it. So if my upstairs neighbor has a problem, the board has nothing to do with it. Is that right?
Yeah, I mean, in terms of maintenance, the declaration of condominium is the document that you would have to look at to determine who's responsible for what. So the statute doesn't really address maintenance issues; it addresses insurance. And so, if you're trying to determine who is responsible for what kind of pipes, then yeah, you're going to have to look at the declaration. If the declaration says that basically, a pipe that serves a particular unit, regardless of whether it's located, is the responsibility of the owner, then yeah, that would be, the responsibility of the owner to repair, replace at their expense.
Sylvia in Tampa, this is an HOA person, wants to know, can we see the delinquency reports?
So the delinquency reports are basically, account ledgers that the association
Right.
has for each owner. The association is required to have that to maintain this accounting, and so it is an official record of the association that really any owner can inspect upon submitting a proper written request for inspection. Okay, so presuming the owner submits a proper, valid inspection request, they should be entitled to inspect it.
Okay. Chris in Tampa, if the management company takes care of the HOA books, do they need to have special insurance?
Take care of the books, like manage accounting or assist
Yes,
with accounting. Yeah,
apparently, yes.
yeah.
Yes, I guess that,
So
I mean,
right. So and this is an HOA.
yes,
The insurance the management company probably has some kind of they will have insurance, liability insurance, crime insurance, fidelity bonding, but more importantly, the association is also required to have fidelity bond insurance on anyone that basically handles association funds, right? And so I don't know if managing the books also means that they have access to association funds, presumably, right? If they're the property
right.
manager. So the association really should have fidelity bond. The statute does allow HOAs to give owners the option to waive the fidelity bond coverage. The fidelity bond basically would provide coverage in the event the property manager or director runs away with association funds, right? So for HOAs, you are required to have fidelity bonding unless, of course, owners vote to waive that requirement. But it is an issue that you would have to present to the owners, and the owners would have to waive that in writing. So they would have to vote to waive that requirement. Otherwise, you should be having fidelity bond.
Okay. It's amazing, Kirsten, that we used to get years ago so many letters about service animals, and now we rarely get anything. But here's one right here from Harold in Tampa. He said, "We have a no pet policy in our docs except for service animals or support animals, and it must be documented. Years ago, the president got a dog. Many filed, many filed against the docs. How do we correct it?"
All right, so the documents prohibit pets, and it seems like one kind of fell through the cracks. One pet was allowed, and then ever since, other owners, residents have brought in pets. Yeah, so you're looking at a potential enforcement issue, right? Because once you fail to enforce a covenant against one owner, the next time that you try to enforce it against another owner, that individual has a basis to claim selective enforcement, right? They can raise that defense. As well as potential waiver defense, right? That you've sat too long in your hands, you didn't enforce the covenant timely, and now you're essentially barred under the law to come and enforce the covenant against me. So the good news is that the law does provide a mechanism for essentially resurrecting this covenant that seems to have that the association seems to have waived. And it is a process that the board can undertake at a board meeting. It's called republication. So with republication, essentially, you're kind of drawing a line in the sand, letting the owners know that you essentially you've not enforced a particular covenant, in this case, the pet covenant, in a uniform fashion. But as of a specific date going forward, the board is going to start enforcing this covenant. Now, the downside of that is that as part of the republication process, the board is required to grandfather in existing violations. So as part of this republication, you will be sending out a memorandum to the owners, letting them know of the intent of the board to republish and start enforcing the covenant in the future. But you will also be, or we recommend that you send out also a registration form, essentially, so that anyone who is currently in violation of that particular restriction, they fill out the registration form and they register their violation. So any owner who does not register the violation timely, essentially, will be considered in violation, and the board can then enforce the covenant against that. For those who do timely register the violation, they are basically grandfathered in, so they can continue owning this pet, presumably until the pet dies or they relocate.
Final question of the day. Your show goes by so fast, Kirsten. It says, this is from Cynthia in St. Pete. Does the board decide if a member should be fined, or is that another committee?
Well, so finding is a two-step process. The board has to initiate the finding process by adopting the fine. And they do that at a duly noticed board meeting. And, before even adopting the fine, I'm sure they've sent some violation notices to the homeowner that if they don't comply, they will be subject to the fine. But once the board adopts the fine cannot be imposed until there's a separate committee that conducts a hearing, right? And then that committee is the one that needs to determine whether or not to essentially ratify the fine that was adopted by the board. So if that committee does not approve the fine cannot be imposed, even if the board adopted the fine.
Well, your show always goes by so fast. We've come to the end of the show. You'll be back again with us next month. Again, I see why they have you teaching so many classes, Kirsten. You're so good at responding and educating people. Let's give everybody the phone number, Kay Bender.
Yes, the phone number again, it's 928-0680. And even though that's our main number, you'll be connected to really any office, any other satellite office of the firm.
And the website, because you got so much great information on there.
Yes, it's kbrlegal.com.
Well, that's going to do it for us today. Kirsten, thank you so much. We'll see you again next month.
Thanks, Steve. Thanks, everyone. Bye-bye.
Yes. And wow, that's going to do it for us today. Hey, I'm so sorry I didn't get to everybody's questions today. We had so many questions from write-ins. That's going to do it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.